Hi everyone. Today we are going to see about MTP Act, that is Medical Termination of Pregnancy Act. So this is a very important act. So every OGcian and a female doctor should know about the provisions given in this act because they will be handling sensitive cases of MTP, that is medical termination of pregnancy, as well as they may encounter a case for criminal abortion. So they have to know what are all the legal provisions given in this act, what they should do and what they should not do. So in this video, I'm just going to elaborate the provisions given in this act. So this act was enacted on 10th August 1971. It was recently amended on 1st October 2021. So the objective of this act is to provide for termination of certain pregnancies by registered medical practitioners. So already we have some existing provisions in the IPC, that is Indian Penal Code. Actually, this IPC criminalizes abortion. So in section 312 IPC deals with criminal abortion with the consent of the women. That is, if it is done before quickening, then punishment is up to 3 years with or without fine. And if it is done after quickening, up to 7 years and fine. Suppose the abortion has been done without consent of the women, then punishment is up to 10 years or life imprisonment and fine. Section 314 deals with pregnant women dies by the act done with intention to cause miscarriage. Someone tries to cause miscarriage to that woman, but the pregnant woman dies either with or without consent. So suppose with consent, then punishment is up to 10 years with or without fine. If such act is done without the consent of the pregnant woman, then punishment is up to 10 years or life imprisonment and fine. 315 IPC deals with act done with intent to prevent child being born alive or cause it to die after birth. Punishment is up to 10 years with or without fine. Section 316 IPC deals with causing death of the quick unborn child with act amounting to culpable homicide. Here the punishment is up to 10 years and fine. Actually, here the intention was to cause the death of the mother, but the offender knows that the woman is pregnant. So because of the injury to the mother, the child dies. So in this case, the punishment is up to 10 years and fine. So here, what are all the drawbacks in the IPC provisions? Actually, these IPC provisions were enacted 100 years back, that is during the British colonial era. So, and they were completely outdated. Okay. So that doesn't suit to the current scenario or the current era. So what we need is a revised law. So for better provisions for MTP. As per the IPC provisions, abortion is a crime. Both the doctor and the pregnant mother were punishable under these sections. Why there is a need for MTP Act? Mostly married women with no necessity to conceal the pregnancy came for abortion. So here we need not criminalize the women because they have the right to preserve their bodily integrity. So that is their right to liberty or personal liberty. So the doctors were confronting more cases of gravely ill mothers with tampered uterus. Since abortion was criminalized at that stage, mostly the pregnant women or mother will not be going to any established centers for getting the fetus aborted. Instead, they will seek to criminal abortion. So they will go to quacks or they will induce abortion themselves, resulting in injury to the uterus and sometimes danger to the life of the mother. So mostly doctors are confronting such cases, that is at the end stage. So in order to avoid all these things, there is a need for this MTP Act. So by enacting this act, we can considerably reduce avoidable wastage of mother's strength, health, and life. It mainly aimed to liberalize the provisions for termination of pregnancy, health measures, danger to mother's life, or risk of any injury to the physical and mental health. And also, it can be done on humanitarian grounds. Mainly, there is the pregnancy has resulted because of any rape or any antisocial behavior, or if a mentally ill person was pregnant. And also, it can be done on eugenic grounds. So that is the risk of child being born with deformities or diseases which can endanger the life of the child. So when to and who can conduct MTP? So a single medical officer can terminate the pregnancy up to 20 weeks of gestational age. If suppose it was more than 20 weeks but less than 24 weeks, that is 20 to 24 weeks, then opinion of two medical officers is needed. At least two medical officers is required to conduct medical termination of pregnancy. Suppose the pregnancy, the gestational age has exceeded 24 weeks, that is more than 24 weeks, then the medical board should decide whether to conduct the abortion or not. So, what is the composition of this medical board? It contains or it includes a gynecologist, pediatrician, radiologist, or sonologist, and also other members as notified in the official gazette of the state or union territory. So, what are all the powers of this medical board? It has the power to allow or deny medical termination of pregnancy beyond 24 weeks. Mainly, it considered the following things. If there is any danger to life of the mother, if there is any fetal anomalies, if there is a chance that the child will be born being incompatible to life, and also if there is a chance that child will be born with physical and mental abnormalities. Also, it has the power to co-opt other specialists in the board. Suppose the board thinks that some other specialists should be included, it has the power to include them to arrive at a decision in a particular case. And also, it has the power to ask for any additional investigation. Suppose if the board members feel that further investigations has to be done for the pregnant women to decide upon whether to go with the medical termination of pregnancy or not. So, it can do that. So what are the functions of the board? It has to examine the women, that is the pregnant mother and her reports. And also, after examining the mother and her reports, it should provide opinion or reject the request for MTP within a period of 3 days. Okay. So once the request has been accepted, it has to ensure that medical termination of pregnancy is carried out under full safety precautions with proper counseling to the pregnant mother within a period of 5 days. So these are all the functions of the medical board. Who are all eligible for termination up to 24 weeks? That is survivors of sexual assault or rape or incest, whether married women as well as unmarried women, minus change of marital status during ongoing pregnancy. Suppose if the husband of the woman dies or if she gets divorced, then she becomes eligible for termination of that pregnancy. And also women with major physical disabilities, mental illness including mental retardation, fetal malformation, humanitarian settings like disasters or emergency situations. So all these situations, the woman is eligible for termination up to 24 weeks. Who can perform an MTP? What is the qualification required by a registered medical practitioner to perform an MTP? So if the medical practitioner possesses a PG degree or diploma in OG, the experience gained through the course period is enough to conduct the MTP. So that is, she or he should possess a PG degree or diploma in obstetrics and gynecology. So next, the medical officers who have been registered in the state medical register immediately before the commencement of this act, they should have at least 3 years of experience in OG practice. If suppose they have been registered after the commencement of this act, they should be compulsorily registered in the state medical register. And they should have undergone 6 months of house surgeoncy in OG, and also more than 1 year experience in OG practice at any hospital recognized by the government. For termination of pregnancy up to 9 weeks, only by medical methods. Termination of pregnancy up to 9 weeks by medical methods. The registered medical practitioner requires more than 3 months experience in OG practice in any hospital or institute recognized by the government, and he should have performed 10 independent cases by medical methods under supervision of an RMP. So up to 12 weeks, that is for first trimester pregnancies, the registered medical practitioner should have assisted an RMP in 25 cases of MTP. At least he should have performed 5 cases independently. The training has to be done in a hospital or training institute that has been approved by the government. So next, we have seen about who can do the MTP and when MTP can be done. So now let's see where MTP can be done. So it should be always done in hospitals established or maintained by the government itself, a place approved for the time being for the purpose of this act by government or district level committee. So how to get approval of a place for conducting medical termination of pregnancy? So what is the role of the district level committee here? At least one member of the district level committee should be an OGcian, anesthetist, or a surgeon. Other members include a local medical professional, an NGO, Panchayat Raj admin. At least one member of the district level committee should be a woman. And the chairperson is the chief medical officer of the district. So the tenure of this district level committee is 2 years. After 2 years, there will be change in the members. So what are all the facilities required for a place to get approval for MTP? So that is, if they are going to conduct MTP only up to 12 weeks, then what are all the things required? Gynecology examination or labor table, resuscitation, sterilization equipments, drugs and parenteral fluids, facilities for treatment of shock, and proper transportation facilities for referral to higher institutions. Suppose they are going to conduct for MTP up to 24 weeks, then there is a requirement for operation table, instruments for performing abdominal and gynecological surgery, drugs and parenteral fluids, resuscitation, anesthetic and sterilization equipment should be there. Suppose if medical termination of pregnancy of more than 24 weeks is going to be conducted at a place, then they need an operation table, instruments for performing abdominal and gynecological surgery, drugs, especially blood for emergency, and parenteral fluids, resuscitation, anesthetic and sterilization equipments. Along with that, they should have facilities for ultrasound guided procedures. So these are all the facilities required for getting approval for MTP. So what is the procedure of getting approval? So that is, first an application should be given by the owner of the hospital or the establishment to the district chief medical officer. So this application has to be given in a form A. So after receiving the application, the district chief medical officer will inspect that place within 2 months. The inspection has to be conducted by the district chief medical officer within 2 months. So after inspection, if the district medical officer feels that the particular establishment fulfills all the criteria, then he will recommend to the district level committee. So after getting recommendation from this district CMO, the district level committee will decide upon granting the certificate of approval, that is form B, within 2 months of inspection. So this is the procedure. Suppose if the district chief medical officer feels that there are some deficiencies in the establishment, he will address those deficiencies. The owner of the establishment has to rectify all these deficiencies and ask for re-inspection. So the re-inspection will be done within 2 months again, and certificate of approval will be given after checking thoroughly. So this is the procedure for getting approval of a place for MTP. So what is the powers of district chief medical officer under this act? So this district chief medical officer can conduct frequent inspections of the establishments where MTP is being conducted. So he also has the power to ask for any documents, drugs, articles, or seizure of the documents, drugs, and articles. And also he can cancel or suspend the approval given already. So he has the power to do that. Once this district chief medical officer feels that medical termination of pregnancy has not been done up to the requirements in this act, then he can directly cancel the approval. So once the approval has been cancelled, the owner can ask for review of cancellation that can be applied to the government within a period of 60 days. Now let us see about consent for MTP. So whether consent is necessary or not, who can give consent, who cannot give consent, let us see about that. Okay, the consent of the pregnant woman is necessary. The consent of the husband or spouse is not necessary. The consent of the parent or guardian is required in case of minor or in case of person with mental illness. For the persons with mental retardation, the consent of that particular women is needed, not their guardians, because mentally retarded persons can decide for themselves. Mental retardation is entirely different from mental illness. Okay, so the consent of the mentally retarded women is required for terminating her pregnancy. So this is regarding consent, and this consent has to be an informed written consent. So after getting consent, the procedure is performed. So how to certify opinion for MTP? There are several forms provided under this act. So form 1 is for opinion by single medical officer, that is for less than 20 weeks. So form 2 is the form for monthly statement to be sent by the head of the institution or the establishment to the chief medical officer of the state. So form 3 is an admission register. So this admission register has to be maintained separately for MTP, and all the cases of the MTP has to be entered in this admission register in a serial number. So this has to be maintained for at least 5 years from the last date of entry. So this admission register is a highly confidential one. Doctor should not disclose the details of this to anyone unless otherwise that particular person is authorized by the law. So, and also this person or the doctor conducting the MTP has to certify in form 1 within 3 hours of terminating the pregnancy. So that is what given in this act. So next form C is the consent form. This is a standard form of consent under this act. So form D is the report of the medical board for termination of pregnancy where gestational age is more than 24 weeks. And form E is the opinion by 2 medical officers where the gestational age is between 20 to 24 weeks. So these are all the forms that has to be used while conducting the MTP, and the admission register has to be maintained separately and confidentially. So protection of privacy under this act. So the privacy or the details of the pregnant mother who is undergoing the medical termination of pregnancy has to be maintained very, very confidentially. So the medical officer should not disclose this information to anyone unless it is a person authorized by the law. So suppose if the medical officer discloses the details of the pregnant women undergoing MTP, medical termination of pregnancy, then he is punishable by imprisonment up to 1 year or fine or both. So what are all the offenses and penalties under this act? So suppose if the medical termination of pregnancy is conducted by a person who is not a registered medical practitioner, then he is punishable by rigorous imprisonment of 2 years to 7 years. And suppose if the particular act, that is a medical termination of pregnancy, has been done at a place not approved by the government, then both the owner as well as the person conducting the medical termination of pregnancy are punishable by rigorous imprisonment for 2 to 7 years and fine. Suppose if there is any failure to preserve the documents or failure to intimate to the state medical officer, or if there is any disclosure of the details to persons not authorized by law, then a fine of rupees up to 2000 is imposed on the medical officer. So these are all the offenses and penalties under this act. So it also provides protection for the medical officers for the act done under good faith. So what is good faith? Any act done to save the life of the woman. Not all the acts claimed to be done to save the life of the woman or acts done under good faith. It should be done with proper care and attention. There is no suit or legal proceedings against the medical practitioner for such act which is done in good faith to save the life of the women. So this act provides that protection to the medical officer. So we'll see about some important judgments related to the medical termination of pregnancy. So in this case, Samrishta Chakraborty versus Union of India 2018 in Supreme Court, the court says that the right of women to have a reproductive choice, it is an inseparable part of her personal liberty. Under Article 21 of Constitution, she has the sacrosanct right to have her bodily integrity. So that is the act says about Article 21, which includes right to life and also includes right to personal liberty. The woman has the personal liberty to preserve his bodily integrity. So this act gives respect to that Article 21. And also it considers the women's right to have their reproductive choice. In another case, Z versus State of Bihar, the court says that there is right to terminate pregnancy on grounds of rape and AIDS. And in cases of mental illness, the person suffering from mental retardation, not mental illness, can give consent for medical termination of pregnancy. Suppose the person is not mentally ill, but she is mentally retarded, then she can give consent for MTP. So that is what the court said in this case. In other case, Suchitra Srivastava versus Chandigarh administration, regarding consent of termination, the pregnant woman's consent for termination of her pregnancy is necessary. It excludes consent of mentally ill women, but not mentally retarded women. Mentally ill person is different from mentally retarded person. Hence, consent of mentally retarded women is necessary. So these were the observations made by the court in this case, that is Suchitra Srivastava versus Chandigarh administration case. In the other case, Mamta Verma versus Union of India, regarding permission for termination of pregnancy beyond 24 weeks. Here, the petitioner was a 26-year-old female in 25th week of pregnancy. The fetus was diagnosed with anencephaly and certain to cause infant's death during or shortly after birth, also known to endanger mother's life. Here, the medical board affirmed the same. So, the termination of pregnancy was permitted beyond 24 weeks by the court. So all these cases were before the recent amendment. So based on all these cases, the recent amendment was done. All these criteria were included in this recent amendment in 2021. So now let's see about what are all the forms available under this act. So this is Form A. This is for application for approval of a place for conducting MTP. So this form has to be fulfilled by the applicant and has to be submitted to the chief medical officer of the district for approval of the place. So this is Form B. Once the chief medical officer of the district completes his inspection and recommends to the district level committee, after scrutinization, the district level committee will issue this Form B or certificate of approval. So this has to be displayed in the center or establishment where medical termination of pregnancy is being conducted. So this certificate of approval has to be put on display. So next is Form C or the consent form. So the first one is the consent by that particular person itself if she is not a mentally ill person. Suppose that person or the woman or the child is a minor or a mentally ill person, then the consent has to be obtained from the guardian, parent or guardian. So next, this is Form D. Actually, this is for the report of the medical board for termination beyond 24 weeks. This is Form D for termination beyond 24 weeks. This has to be provided by the medical board. So next is Form E. So this is for gestational age beyond 20 weeks until 24 weeks. So for at least 2 medical officers has to certify in this Form E. So these are Form 1 for medical termination of pregnancy, opinion by a single medical officer, that is less than 20 weeks. Next is the Form 2. This is the monthly statement, which has to be forwarded by the or provided by the head of the institution or the establishment to the chief medical officer of the state. So this is Form 3, admission register. So the entry has to be done in this pattern, which is given in the Act. So Form 3 includes serial number, date of admission, name of the patient, wife or daughter of, age, religion, address, duration of pregnancy, reasons for which pregnancy is terminated, date of termination of pregnancy, date of discharge of the patient, result and remarks, and name of the registered medical practitioners. So all these things has to be entered in a admission register and has to be maintained separately. And this admission register has to be maintained very, very confidentially. So I hope that I have elaborated the provisions given in the Medical Termination of Pregnancy Act, and hope it will be useful for your day-to-day practice and for all the precautions and what are the procedures you should follow while conducting a medical termination of pregnancy. So thank you guys. Thank you for all the support. Thank you.